Why would I ever send something to the Board of Veterans Appeals if it's just going to take 3 to 4 years to get an answer? This is something that I got in a question on a comment from one of my previous videos. If you have questions, leave them in the comments and I'll try to address them in future videos. I really appreciate this question because this really gives us insight into how an accredited attorney or agent or even a VSO thinks about their appeals. If you get a rating decision you disagree with, you have 1 year to appeal that decision, and you have 3 options: the supplemental claim, the higher level review, or going to the Board of Veterans Appeals. When you go to the Board of Veterans Appeals, you can actually pick from 3 more options. You can submit additional evidence, you can do a direct review just based on the evidence already in the file, or you can request for an in-person hearing, and by in-person I really mean video conference because no one's in person these days. If you do the in-person hearing, you actually get 90 days after the hearing to submit additional evidence. Why would I ever do this if it's going to take the Board of Veterans Appeals between 3 and 4 years to actually review my file? There are a couple reasons. First, my strategy is, as of 2023, has been to only take to the Board of Veterans Appeals those decisions which I do not think will be granted at the regional office. But let me back up a moment. What can the Board of Veterans Appeals actually do? Well, once you file your claim at the Board of Veterans Appeals and the time goes by, it actually gets distributed to a judge, and the judge, along with their team of attorneys, will review the file and make a determination for you. That determination can either be to grant whatever you're asking for, they can deny whatever you're asking for, or they can do what's called a remand. And the remand is where the Board of Veterans Appeals actually directs the regional offices, or rather the VA as a whole, to do something to your file. And that's usually gather more evidence, conduct more medical exams, etc. I don't like getting into situations where I'm waiting 3 to 4 years only for the Board of Veterans Appeals to remand something, not actually make a decision. So what does this leave me? In my opinion, based on the individual cases I'm looking at, I am leaving the Board of Veterans Appeals lane, or rather the appeals on those, to just cases in which I think that the regional office can't make a decision that's going to help my client. That's usually when it comes to weighing positive and negative evidence, or finding for an earlier effective date based on case law that just hasn't been incorporated into the VA's manuals, but that the Board of Veterans Appeals, as lawyers, is keeping their eye on. This is incredibly complicated stuff, and it's only something I do after really assessing a case and trying out every avenue at the regional office, which is significantly faster, generally speaking, than going to the Board of Veterans Appeals. So an example might be if I have a case where we've submitted an independent medical opinion, you might know it as a nexus letter, and for some reason the regional office denies it. I might file a higher level review on that because I don't want to just get in line at the Board of Veterans Appeals and wait 3 more years. And the higher level review might reject that independent medical opinion as well. If it goes to the Board of Veterans Appeals, I know that a veterans law judge well-versed in the law will take this claim, this independent medical opinion, and give the proper weight it deserves compared to, say, whatever the C&P exams are in the file. Again, this is a very specific circumstance. Not all the cases are the same. I have had some luck getting the VA at the regional office level to actually acknowledge these independent medical exams, but it doesn't always happen. Sometimes you have to send it to the Board of Veterans Appeals. Another issue is sometimes the VA has a hard time figuring out reserve status or effective dates, especially if it's a complicated effective date matter. It really depends on the higher level decision review officer you get. And your odds aren't great that if it's a very nuanced or complicated argument, you might have to send up to the Board of Veterans Appeals. But I will often at least give it a shot at the higher level review level, because that's only going to take me 90-ish days, hopefully. So with that said, it's very specific when I send stuff to the Board of Veterans Appeals. It's when I've only exhausted other options at the regional office, and when I know that, or when I hope, when I don't think the ultimate outcome will be a remand, because I want to avoid remands at all costs, because that just adds more time to the entire process. And quite frankly, I'm not convinced that the VA always listens to the Board of Veterans Appeals when it comes to implementing these remands. I'll talk about that more in another video when I talk about the Stiegel case. In any event, thank you for tuning in. If you have any questions, leave them in the comments. And as always, like, subscribe. And if you've been denied or you're frustrated with your claim in the appeals process, reach out, see what we can do to help you out. Until next time, take care.